Supreme Court. So we are now faced with the issue of what is the weight of a dissenting opinion. The Supreme Court itself said in the 2008 case concerning Mr. Amado Makasait, quote, the Supreme Court stated that elementary decision-making teaches that we cite the majority opinion as precedent, not lonely dissenting opinions. Another case, 2006, Yes V. Kapisanan. It is the majority opinion and not the dissenting opinion that is the controlling jurisprudence. These are accepted facts in law school. Why do we have to debate these topics? We can safely take them for granted. So to return to Article 7, our quest here is factual in nature. Was the Chief Justice personally and individually responsible for what are perceived deficiencies or irregularities in the issuance of the TRO? The TRO is a subject matter, and the target of this particular Article 7 is the Chief Justice, the respondent. The issue therefore is, can one judge be held liable for the decision of a collegial body? Here is the Supreme Court speaking in an administrative case filed by an individual against certain justices of the Supreme Court, and here is what the Supreme Court said. Although the Chief Justice is primus inter pares, first among equals, he cannot legally decide a case on his own because of the court's nature as a collegial body. Neither can the Chief Justice by himself overturn the decision of the court, whether by division or the en banc, whether by division or by the entire Supreme Court. And here is an excerpt from the book, Judicial Opinion Writing by Joyce George, in its 4th edition, as early as 1993. In writing an opinion, the writing judge is involved in a joint venture. The end product is not his opinion alone, but rather that of all the members of the panel who form the majority. So I return to the issue at hand. The issue at hand is simply like this. Is the witness qualified under the rules of court to testify on this particular matter? Answer no. She said no herself. She said, I'm not a member of the court. I've not been there. I was not present. I was just reading the opinion, the dissenting opinion of one of the dissenting justices. That's what she said. So she's not testifying according to her own personal knowledge. That falls under the hearsay rule. As I said, I admit that there are 11 exceptions to the hearsay rule. Therefore, prosecutor has the burden of showing that at least one of the 11 exceptions to the hearsay rule applies. Otherwise, there's no point belaboring this issue. We can move on. Let's move on, counsel. Thank you, Mr. President.
Thank you.
Mr. President, may I react to the distinguished lady senator and now international jurist?
Proceed.
Mr. President, point of order. He will engage in a colloquy with me, a judge. The judge has spoken. Now the judge is taking time to deliberate on what she has just told the court. I don't think this is proper.
Counsel,
you should debate among yourselves. You do not debate with a judge.
Yeah, counsel, I'm sorry. A member of the court objects to any further discussion. So
Yes,
I will make a ruling.
Mr. President, may I just add for 2 minutes a remark? Well, one of the exceptions to the hearsay rule, one of the 11 exceptions to the hearsay rule under Rule 130 is Section 44.
And which says?
Yes, let me read that. Yeah. It says, Section 44 of Rule 130, one of the 11 exceptions to the hearsay rule. And it says, quote, entries in official records. Entries in official records made in the performance of his duty by a public officer of the Philippines or by a person in the performance of a duty especially enjoined by law are prima facie evidence of the facts therein stated. This is an exception
Yes.
to the hearsay rule, and therefore the burden of persuasion is shifted. We have exercised our burden.
Mr. President.
Then the burden is shifted to the defense, to demonstrate to the
May I
court
beg the
that we do
indulgence
not
of
fall
the
within
lady
this
senator
exception.
from
Yeah.
Iloilo to let the counsel finish, and then I will recognize her.
Thank you.
Yes. Proceed.
Yes, I'm finished with my statement.
That does not apply, counsel. Let me educate you. When an official custodian or other representative qualified by that office or authorized by that office to issue an official record does so, then the presumption applies that what is stated in the official record is correct. To that extent, therefore, there is an exception to the hearsay rule. That person or that custodian or that record keeper does not have to explain why his record is that way. You just have to take it on faith. That is the meaning of that. But we are talking of a dissenting opinion by collegiate body, the Supreme Court. So, if the dissenting opinion contains certain narrations of fact, which in fact are intended to dispute what the majority opinion has issued, you cannot prima facie presume that the dissenting opinion is correct and the majority opinion is wrong. That's why I read you those cases where the Supreme Court repeatedly said, you rely on the majority opinion, not on the dissenting opinion. That is why I was warning you already, do not engage in a colloquy with the judge. That is not allowed by the rules of the impeachment court.
All right.
Put it in your memorandum.
All right. May the presiding officer now make a ruling? Is there any objection? All right. It is the ruling of the chair that to the extent of the facts narrated by the witness on the basis of the dissenting opinion, let them remain as a part of her testimony. Let them remain as a part of the record as a consequence and part of her testimony here as a witness. But to the extent of the truth or falsity of what the dissenting opinion of Justice Sereno contained, to the extent of those facts, whether they're true or not, that the Chief Justice influenced this or the Chief Justice did that or somebody else did something else, then to that extent it is hearsay because the witness was not present when those things were being done or being said. And so I will allow the testimony of the witness to remain into the record and admonish, or rather suggest to the court to disregard whether the statement of the Chief Justice or what he did or other justices did in the course of their deliberation, because those are not within the competence of the witness to testify on, so therefore those are hearsay.
Thank you, Your Honor. I was about to make a short manifestation, Your Honor, as to the effect of a declaration of statement being considered as hearsay.
Yes.
Because there are plenty of jurisprudence to the effect that whether objected to or not, if the testimony is hearsay, it shall not and must not be considered by the court in rendering a decision, Your Honor.
Yes, but we must remember that we are not trying a criminal case. We're trying an impeachment case. Although there is a penalty, the only penalty is not loss of freedom or infliction of an economic burden, but the removal of the respondent from his position and his disqualification. And therefore, the principle of the rule on hearsay, the hearsay rule contained in our rules of evidence, do not apply strictly in impeachment cases, as far as I could remember what I read about the experience of the United States in impeachment cases. It's true that in a strictly criminal case, the hearsay rule is a very strictly adhered to as a rule of evidence, but not in an impeachment case. And that's why I made the distinction between the truth or falsity of what was related by Justice Sereno in her dissenting opinion and what the witness now said based on what was contained or the information being presented to her on the basis of the dissenting opinion of Justice Sereno. To that extent, and to the extent of the dissenting opinion, let it stay as a part of the testimony of the witness. So order.
Now, I am heavily thankful, Your Honor, for the announcement made by the Honorable Presiding Justice. But I am also thankful for being allowed to make that manifestation of record, because that is a rule not only applicable to civil, criminal, and other cases, Your Honor. And I am searching in vain a ruling or a rule of procedure insofar as the impeachment court is concerned relative to hearsay evidence. If we examine the rules of procedure, there is nothing in there, Your Honor.
Counsel, I'm going to ask you to read the book of Charles
On impeachment. Yeah.
The one written by
Black.
Charles Black,
Yes, Your Honor.
and also the book written by Raoul Berger of Harvard.
Yeah.
These two books will tell you that the hearsay rule is not adhered to strictly in impeachment cases.
Thank you, Your
If
Honor.
you want, I can bring them here. I think I have them in my office upstairs.
Yeah. I have gone over the first book, Black, Your Honor, but the second one, I have not seen it. I do not know. Thank you, but thank you for the information.
Raoul Berger is a Harvard man who wrote a very extensive study on impeachment trials in America. And he cited a lot of authorities to say that hearsay rule does not strictly apply in impeachment cases. And so I understand your position, but we are not proving the guilt or innocence, or the guilt, rather, of the respondent beyond reasonable doubt. We are going to decide this case on the basis of the quantum of evidence that we think is best to be used in determining whether he is guilty or not guilty, not beyond reasonable doubt. Because this is not a criminal case. It is akin to a criminal case, but not really a criminal case. And that's why I made that ruling, and so let it remain as a ruling of the court.
All right. Thank you, Your Honor. I am through with the witness. Thank you, Madam Secretary.
Thank you, sir.
Okay.
Mr. President.
Let us now discharge the
Mr.
distinguished
President,
Secretary of Justice.
Mr. President, there are a number of senators who have made reservations to ask
Yes.
questions to the witness.